I'm Geoff Stone, for those of you who don't know me. And I'll be talking this afternoon about the Supreme Court's 1972 term and the experience of being a law clerk with Justice Brennan. There's no Chicago's best idea in here, I have to concede, but I thought it might be interesting to hear something about that time. And maybe this will lead you to have some of Chicago's best ideas, so that would be good. Let me apologize in advance. I have a cold with a terrible cough, and I'm sure it will at various times interrupt. So I assure you it aggravates me more than it will you. But if that happens, you should know that it's not me choking to death. Okay, first of all, let's set the time period just a bit. 1972-73, law clerks arrive in the summer. And 72-73 was the year of the 1972 presidential election, in which Richard Nixon trounced challenger George McGovern. Watergate, the break-in, happened that summer, and during the course of the 1972-73 term, Watergate began unraveling in the newspapers and the beginning of the congressional hearings. And so this was a major subject of interest during this period. The Vietnam War wound down, at least in terms of American troops, and the last American soldiers left Vietnam in March of '73. And the World Trade Center was opened in 1972-73. So that just gives you a sense of the time period we're discussing. Let's say a word about the players here. In terms of the justices, there were 9 of them. And at that time, the justices were Chief Justice Burger and Justices Douglas, Brennan, Stewart, White, Marshall, Blackmun, Powell, and Rehnquist. They consisted of 9 men, no women, obviously, 8 whites, and 1 African American, Thurgood Marshall. They were appointed by 5 different presidents. 1 was appointed by Franklin Roosevelt, 2 were appointed by Eisenhower, 1 by Kennedy, 1 by Johnson, and 4 by Richard Nixon. There was a dramatic change, one of the most substantial turnovers in the history of the Supreme Court, immediately before the 72-73 term. Chief Justice Warren and Justices Black, Harlan, and Fortas stepped down, and Richard Nixon replaced them with Chief Justice Burger and Justices Blackmun, Powell, and Rehnquist. So this was a period of really dramatic change in the makeup of the court and in the attitudes and views of the justices. We'll come back to that later. In terms of the other players in all this, the law clerks, there were 27 clerks. Each justice had 3. The chief had 4, but Douglas only took 2. There were 25 men and 2 women, and all 27 were white. 18 of the 27 clerks, or 2/3, graduated from Harvard, Yale, Chicago, and Columbia. Those 4 schools dominated. And the other 9 clerks came from a broad array of different schools, ranging from Mississippi to Stanford to George Washington to Notre Dame, all 9 of those other clerks came from 9 separate institutions. One of the interesting things about this term is that it was the first term in which justices began self-consciously selecting their law clerks with an eye on their ideology. And that is, in particular, that year, Justices Rehnquist and Blackmun went out of their way to find 3 each conservative law graduates to be their law clerks. Until then, for the most part, justices did this in what they thought was a relatively meritocratic way without much obvious attention being paid to ideology. But Rehnquist and Blackmun both clearly felt they wanted law clerks who would be simpatico with them and who wouldn't subvert them by bringing to bear a different perspective on the law than the one they wanted to pursue. And that was both obvious and troubling to the clerks and to some of the other justices even at the time. And that certainly continued in the years since, particularly with the conservative judges. Okay, in succeeding years, 13 of the 27 law clerks went into legal academia. The others went into a broad range of activities, including private practice, government, public service, business, and the like. And of course, there's a lot of moving in and out of different fields in the years since then. 3 of the 27 clerks became law school deans, myself included, and 3 of them became federal judges and are still sitting as federal judges. All 9 of the then sitting justices are now deceased. All 27 of the law clerks, happily, are still around. And the average age of the law clerks now, it turns out, is almost exactly what the average age of the justices was in 1972-73. Okay, let me say a word about Justice Brennan in particular, since he was the one whom I clerked. Brennan was a quite remarkable individual. He was a beloved person by almost everyone who knew him. Brennan had a kind of Irish twinkle in the eye manner. He was always touching. He loved to sort of, in any conversation, have his hand on your arm or to hold your hand while he talked. He was warm, genial, good-natured, generally upbeat, although this year took a toll on him, and always interested in the clerks, interested in their personal lives as well as their professional activities. He would meet with the law clerks every morning at 8 o'clock for an hour for coffee. Brennan would always get to the office around 7. He was an early riser and didn't expect the clerks to get there at 7, but he did expect them there by 8. And was a very hard worker. The way things worked in Brennan's chambers is that he, alone among the justices at that time, read all of the cert petitions himself. Unlike the other justices, he did not rely upon his law clerks to screen all the cert petitions and to either write memos or to pick the ones which they thought were most deserving of review. Brennan felt it was a very important educational activity for him to read the cert petitions because it gave him a larger sense of what was going on in the lower courts and a feel for the types of issues that were percolating. In terms of writing opinions, the way Brennan typically worked is that one clerk would be assigned to each case, and the clerks would decide that. And then Brennan did not have bench memos. Most judges and justices then, at least, required their clerks to write maybe a 20-page memo that sort of outlined the arguments on each side. Again, Brennan did his own work in that respect. He always read the briefs himself and didn't expect the clerks to do that. But in those morning sessions, one of the things we always did was to discuss the pending cases about to be argued, and talk about what questions would be appropriate for oral argument, what the strengths and weaknesses of the competing arguments were, and how Brennan might sort his way through those arguments. We also, in those morning meetings, by the way, talked about Washington Redskins, which was one of the loves of Brennan's life, and Watergate and Richard Nixon, whom he loathed, and a general range of other subjects. If Brennan was assigned the majority opinion, and that works in the following way. The Chief Justice, if he's in the majority, or the senior justice in the majority, assigns the responsibility to write the opinion to whichever judge the Chief Justice or the senior justice wants to write the draft of the majority opinion. So if Brennan was writing the opinion, typically what he would do is come back after conference, and he would discuss all of the discussion of the cases and the votes and which cases we were going to be writing majority opinions in. We would discuss the way in which the opinion might proceed, and then the law clerk would basically go off for a couple of weeks and work on a draft in obviously discussion with the other clerks, and then eventually present it to Brennan. And he was pretty rigorous in his reviews of the opinions. If he really liked one, he would make very few changes, but frequently he would rewrite opinions almost from scratch. And so he basically had the view that if the opinion was good, great, I don't need to monkey with it. But if it's not what I want, then he had no problem with actually redoing it rather than just telling the law clerk, go back and you redo it. Okay, the court, from an overall perspective at that time, should be understood in the context of this dramatic transition brought about by Richard Nixon's good fortune of having 4 openings very early and more or less at the same time in his first term. Before Nixon made those nominees, the court was the Warren Court. And the Warren Court was known, obviously, for taking an activist judicial approach in interpreting the Constitution to enforce and to protect individual rights in circumstances which often were more aggressive than predecessors had taken. So decisions across a broad range of areas, beginning with Brown and Board of Education, including Reynolds and Sims, which involved one person, one vote, including Mapp and Miranda and Gideon versus Wainwright, involving the exclusionary rule and the warnings that have to be given to people when they're in custody before interrogation, and right to counsel in criminal cases, are illustrative of the kinds of decisions that the Warren Court made. The prohibition on school prayer was a Warren Court decision, requiring various legal protections under the Due Process Clause for welfare recipients and others was another element of the decisions of the Warren Court. And the Warren Court became the target of conservative view in the United States, the claim being often that these justices are simply distorting the meaning of the Constitution to impose their own personal political preferences on the nation. And in this debate, in this argument, Richard Nixon took the view that the court was out of control, needed to be reined in, and in his 1968 campaign made that a significant theme of his election, that we needed to change the court, and he would do so. Much of this focused on law and order, much of it focused on the attack on the Warren Court's criminal procedure decisions, but it also had important ramifications for Establishment Clause decisions, and such as the school prayer decision, and it was a major theme in the campaign. Now, the way that debate was structured by Nixon was that the Warren Court were run-amok liberals, and what we need is conservative justices who will exercise judicial restraint. And so the battle lines were defined as activism is bad and passivism is good. Justices should be much more deferential to the other branches of government. They should be much more passive in their interpretation of constitutional provisions. And therefore, the justices that Nixon nominated, the men that Nixon nominated to the court, were all touted as individuals who would exercise that kind of restraint. And in fact, they did. Powell, Blackmun, Berger, and Rehnquist were conservatives of a certain type. They were generally politically conservative, but their view of the judicial role, framed by the backlash to the Warren Court, was one of restraint. That is, we don't find things unconstitutional unless we really have to. And any doubt should be given to the elected branches of state or federal government. This is made clear. I wrote a piece in the, I think 1980 or 81, in which I looked at the behavior of the court. And from 1961 to 1981, the shift from the heyday of the Warren Court to the heyday of the Burger Court, the court went from invalidating, in constitutional cases raising constitutional issues, it went from invalidating the challenged law 86% of the time in 1961 to invalidating it only 19% of the time by 1981. And this was the product of two factors. One of them was the certiorari process. That is, the Warren Court was taking cases. In 1972-3, there were some 5,000 cases seeking review in the Supreme Court. The court granted cert to about 120 of them. So it's very selective which cases actually get heard in the Supreme Court. The Warren Court was looking to take cases that would enable it to move constitutional law in directions that they felt were appropriate and necessary. Whereas the Burger Court was basically looking to take cases where a lower court had held something unconstitutional, where it could reverse that. Okay, so a large part of this was not just in the jurisprudence of the justices, activism versus pacifism. It was even more than that, more obviously than that, in the certiorari process, which type of case you're looking for. And both were actively using the cert process, perfectly appropriately, to, in part, pursue the changes they felt that were needed in the law. So the Warren Court was being activist in its decision-making, and that led it to take cases that would enable it to make the changes it wanted to do. The Burger Court was looking to withdraw and was therefore searching out cases that gave it an opportunity to slap down courts of appeals that had been activist in deciding cases that the Burger Court wanted to say, no, that's not how we play. Okay, the fear of liberals with the appointments of these conservative, very conservative justices, or thought to be very conservative justices at the time, was that Berger, Blackmun, Powell, and Rehnquist would lead the charge to overturn many of the Warren Court decisions. That they would actually overrule cases like Mapp and Miranda and Gideon and school prayer decisions and so on. In fact, that's not what happened. In fact, for the most part, the conservatives appointed by Nixon honored, at least to a substantial degree, the Warren Court precedents, but construed them as narrowly as possible. So that instead of overruling Miranda, the court would, whenever it had the opportunity, would restrict its scope. And this was true across the whole range of Warren Court decisions. So what the Burger Court was doing at this time was essentially not overruling prior precedents, but interpreting them narrowly to be passive, to reflect a passive view. Passive here doesn't mean anything but other than, do you exercise the power to hold things unconstitutional, or do you abstain from doing that? And by interpreting all these decisions narrowly, they were acting out of the kind of restraint that conservative values at the time were thought to represent. Okay, a lot of these decisions were incoherent in the sense that the logical application of a precedent may lead to X result. And if you as a lawyer were simply sitting down and looking at the case that said, well, does Mapp apply in this situation, or does Miranda apply in this situation? And you were trying as a lawyer to figure out, should it apply or should it not apply? In many instances you would say, well, yeah, but regardless of what I think of Mapp or Miranda, it should apply in that situation, given its core reasoning and given the basic precedents of the court. What the Burger Court did was often to stop things short, even if you really couldn't coherently justify that decision It was simply saying, we've gone that far and no further, and we don't really care very much about what logic should suggest. Logic consistent with the underlying opinion. And again, this is not meant as a criticism of their decision-making, simply as a description of how they were acting as conservative, what they thought conservative justices meant. Okay, the other thing they did in this respect was to cut doctrines that were in the process of evolution short. So at any given time in the Supreme Court, there are many doctrines that are moving towards a certain end. And you can see where they're headed, even though the court hasn't decided to take step 3 before it takes step 2. And in a number of areas, the court, again, just stopped. It's literally put up a stop sign and said, that's as far as we go. And so, as a consequence, there are a range of issues, a range of doctrines in constitutional law that you can see that existed up till 1973, roughly, were clearly headed along a certain path, and then got stopped dead, and now become sort of oddities. Now you look back 37 years later, and you say, what were they doing there? That is, in the original cases. And the answer to that is frequently that the Berger court just changed the direction of the track and prevented any further development of this. So 2 good examples of this for those of you who are somewhat familiar with constitutional law. One of them is the Supreme Court's fundamental interest doctrine under the Equal Protection Clause, where the court was holding that certain the nature of the interest distributed unequally was relevant to how much justification the government must put forth in order to allow it to restrict this interest in an unequal manner. And I'll give a more concrete example of this in a few minutes. But that doctrine, which was very robust in the 1960s and up until around 1973, literally got stopped dead in 1973. So all the prior decisions under that doctrine continued to be honored on their own terms, but intellectually it sort of gets stopped dead. And another example of that worth noting is the Supreme Court held in 1969 that an individual has a constitutional right to possess obscenity in his home. And that decision, understood in context, was clearly a step towards saying consenting adults have a constitutional right to have obscenity. But the Berger court cut that short and basically said, no, we'll interpret that decision as saying you have a right to have it in your home because of your privacy interest, but you don't have a right to get it in the first place, so you can look at it. And again, the explanation there is the Berger court would never have taken the first step and didn't want to overrule the first step, so it sits there as an oddity. That means if you can get obscenity and you can get it into your house, you're home free. But you have no right to get it anyplace. Okay. Now I want to digress a little bit to put what I've said about the Berger court in context. So a question here that is really interesting to me is, what does it mean to be a conservative justice? Okay, in 1972-73, and for the decade after that, what it meant to be a conservative justice was a justice who was committed to judicial pacifism. This was a principled, intellectually coherent, institutionally coherent position. I would argue it was not the right position for judges, but the basic approach was we don't invalidate anything unless there's a clear and compelling reason for doing so. Otherwise, hands off from the standpoint of the courts. And that's what conservatism meant at that time. And in the public discourse, quite appropriately at that time, the idea of conservative and judicial restraint were essentially synonymous. Okay, the problem then arose, well, does that mean judges just basically sit on their hands and don't do anything except to say, okay? And so beginning in the late 1970s, the Federalist Society, which then came into existence, and the Reagan administration began to see if there were ways to justify a jurisprudence that was at the same time restrained, but also allowed the court to actually do something. In effect, the question was, well, when can the court do something other than just defer? And that's where the argument about originalism came from. Now, originalism has always been a theory from the very beginning, but the modern version of originalism came into being as part of the deliberations of the Federalist Society, trying to figure out what's a conservative jurisprudence other than deference, other than restraint. And the idea became, well, it's legitimate for a judge to interpret the Constitution in such a way, even if it's relatively activist, if the decision is in accord with the original intentions or understandings of the framers of the provision. So once one understood the original meaning, one can then say, okay, we now can be activists in enforcing that original meaning. And so this was a way that conservative thinkers tried to figure out how to maintain a general presumption of deference, but still at the same time allow the use of a degree of activism when warranted by the Constitution. Originalism, as defined in that way, is a potentially principled, sensible approach to constitutional interpretation. The difficulty with it is twofold. The first is that it's almost impossible to actually know with any degree of detail what the original understanding or intention or meaning of the framers was on almost any question that would come before the court. The only way to resolve that is normally by simply what presumption you want to put in place. If the presumption is that we don't invalidate anything unless we absolutely are sure the framers themselves intended to invalidate it, then and there, at the time they were drafting it, then we would invalidate almost nothing, because there's very little evidence on what the framers intended to hold unconstitutional in any specific sense. But if you open up the doctrine of originalism to, well, the framers liked free speech, their original intent was to protect free speech from government interference, well, then you have original intent to support something, but that's so vague it's not clear what that means. And the other problem with originalism is that it is incoherent, or it's inconsistent with what the framers themselves thought about the Constitution. That is, one thing that's clear is that the framers themselves did not intend provisions like those in the First Amendment, Congress shall make no law abridging the freedom of speech, or the Equal Protection Clause, the due process of law, to be limited to their own thinking at that time. There's absolutely no reason to believe that's what they thought. They clearly thought they were writing something for long into the future, and that would be aspirational, not statutory in its scope. So originalism taken seriously runs into the problem that it's incompatible with originalism. Okay, but that, in any event, if pursued seriously and rigorously, would be, at least in theory, a coherent view of the constitutional law. What's happened, however, in the last 25 years is that conservatism as a judicial methodology has changed dramatically, so that it's neither judicial restraint, nor is it originalism, but it's simply conservative judicial activism. And justices like Scalia and Thomas and Roberts and Alito and, to some extent, Kennedy are far to the right of Powell, Berger, Blackmun, and Rehnquist. As Justice Stevens has often pointed out, all five of those conservative justices are considerably to the right of anyone on the Supreme Court when he joined the court in 1976. So whereas the first group of conservative justices were pacifists, the second group are not in any way pacifists. I haven't looked at the percentage of constitutional cases where the court today invalidates, but I would guess it's somewhere between the 19% and the 86%, and rapidly moving up towards the 86%. And recent decisions like Heller on guns and Citizens United on speech rights of corporations and the like are a manifestation of a completely different judicial conservatism than the one that the Nixon appointees had. they would undoubtedly have reached the opposite result in all those cases, because they were all highly controversial constitutional claims, and if you're being a pacifist, you would presumably just say it's not for us to decide this. Okay, coming back then to 1972-73, so the understanding of what a conservative justice was completely different at that time. Now, let me give you examples of a couple of decisions from that term, and then I'll open it up for discussion. First, obscenity was a really hot issue, so to speak, at this time. The Supreme Court had held in 1957, in an opinion by Justice Brennan, that the First Amendment did not protect obscene expression. The problem then arose of defining what you mean by obscene expression. How do you know it when you see it? Quoting Justice Stewart. What's the test? And from 1957 to 1973, the court struggled with trying to come up with an acceptable definition of obscenity that could be applied by jurors and by lower courts in a reasonably coherent, consistent, rational manner, without much success. In 1973, the court decided, the 72-73 term, the court decided to revisit the issue. At that time, Justice Brennan, who had initially written the Roth case, the decision that held that obscenity was a low-value speech, had come to the view that courts cannot define obscenity with sufficient clarity to justify applying the doctrine as broadly as it had been applied before. And so by this term, he had reached the view that obscenity can constitutionally be banned only for children and non-consenting adults, but that consenting adults would have a constitutional right under the First Amendment to have access to obscenity, primarily, in his view, because of the difficulties of defining it and making the doctrine meaningful in an acceptable way. And this was the logical extension of the Stanley case I mentioned earlier about obscenity in the home. So for Brennan, this was just a continuation of that line. Three other justices shared this view, Douglas, Marshall, and Stewart. And the question was how the new Nixon appointees would respond to the issue. Going into the oral arguments in the case, Brennan was hopeful that Justice Powell would see things his way. And Powell, in fact, indicated in conversations with Brennan that he thought that this was a sensible way of understanding the First Amendment. We shouldn't be restricting grown-up adults from having access to this material if they want to have it, regardless of what we think of its value. Now, the problem was that Justice Powell was a Southern gentleman who had no concept of what obscenity actually was. He thought it was like, reading Lolita or Lady Chatterley's Lover, which have been held to be obscene. And when he walked into the Supreme Court movie theater to see the films that were at issue in the 1973 cases, he was horrified. And according to Brennan, when Powell came out, Brennan just looked at him and said, "You lost." And so the case came down 5-4 in the other direction. The four dissenters arguing that there should be a constitutional right of adults to have access to obscenity as long as it's consenting adults. The majority reaffirming the earlier view, and indeed also expanding the definition of obscenity from what it had been before, both to try to make it more clear and also to expand its reach to cover more material. A second interesting case was Frontiero versus Richardson, which is an important sex discrimination case under the Equal Protection Clause. Until this time, the Supreme Court had never recognized that laws discriminating against women were any different from laws discriminating against people driving trucks or against people who don't have a law degree. In other words, under the Equal Protection Clause, the basic view was that although discrimination against blacks, for example, required a very rigorous degree of justification, most classifications only require a rational basis and they're upheld under the Equal Protection Clause. And up until then, that had been the approach with respect to gender. A couple of years earlier, in a case called Reed versus Reed, the Supreme Court addressed a law discriminating against women and invalidated the law on the ground that it was irrational. In fact, however, applying ordinary equal protection analysis, there was nothing at all irrational about the law. We would find it offensive, but it was perfectly rational from the standpoint of ordinary rational basis review. So Reed was clearly perceived as a kind of disingenuous opinion, reaching the, quote, right result, but not being willing to do anything to acknowledge that the doctrine was was evolving. So Frontiero comes before the court in 1972-73, and it involved a direct discrimination against women in the context of benefits of soldiers. And the court voted 8-1 to invalidate it in conference, and Chief Justice Berger assigned the opinion to Justice Brennan. And Brennan came back from conference and said, okay, we're going to invalidate this on the basis of Reed versus Reed, the decision 2 years earlier that said prior sex discrimination was irrational. And I was the one who was working on Frontiero, so I was asked to draft the opinion. And it was a fairly simple case, so it didn't take all that long to do the opinion. And I wrote an opinion that would have held it unconstitutional as irrational, citing Reed versus Reed. But the more I looked at it, the more I thought, this is totally dishonest. I mean, there is a doctrine of rational basis review. It's widely understood. This is a rational law under that doctrine. And therefore, I decided to try writing an opinion that would make the argument that discrimination on the basis of sex is suspect under the Equal Protection Clause and therefore is subject to a higher standard of justification than mere rational basis review. And that explained, I argued, Reed v. Reed, and it's the right way to interpret the Equal Protection Clause. And I wasn't sure what to do with this second opinion, but I finally decided to just leave it for Brennan with the first draft, the Reed v. Reed draft, late at night, and so he didn't see me doing this, with a note that just said, you know, the first draft is the one that you asked for. I have problems with it in terms of whether we're really being honest in this reasoning, so I decided to take a shot at writing this alternative opinion, to see what you thought. And I came in the next morning at 8 o'clock, and Brennan had already circulated both opinions to the other 8 justices, saying that he had agreed to write the opinion in conference on the basis of Reed v. Reed, but he'd been persuaded that it was not an intellectually defensible opinion, and therefore he intended to file, for himself at least, the second version of the opinion. And within a couple of hours, Justices Douglas, Marshall, and White sent a note saying, I join Bill's opinion, the second version. And then we waited. And 4 months passed, and Justices Powell and Stewart took the view that given the fact that the Equal Rights Amendment was still in play at this time, that the court should not decide this case on grounds that sex is suspect under the Equal Protection Clause, because it would be preferable if the ERA were to be enacted that that doctrine would emerge out of the Equal Rights Amendment rather than out of the Equal Protection Clause. And so they sort of tried to persuade Brennan to go back to the first opinion. He'd become convinced that it was not something that was really defensible. And so, unfortunately, Frontiero never got the 5th vote. So the 4 votes there was the plurality opinion. And the other members of the majority filed short, essentially a couple of line concurring opinions, saying they agreed with the results, C. Reed versus Reed. And the court never quite got back to that position on gender discrimination. It ultimately has given significant protection against laws discriminating based on sex, but never quite to where the Brennan opinion at that time advocated. A third example is San Antonio School District versus Rodriguez. And this is a case that illustrates what I was saying earlier about how doctrines get shut down. So in the years leading up to 1972-73, the Warren Court in particular had basically concluded that certain inequalities involving certain individual interests that are fundamental to the individual cannot be justified by mere rational basis review, but have to be subjected to a more demanding justification. The clearest example of that was voting, where the court essentially said that in making distinctions among voters, mere rationality is not sufficient, that there has to be a substantial justification to treat citizens differently from one another when it comes to the exercise of the franchise. And there were other rights, like the right to travel, that the court had identified in this way. In San Antonio versus Rodriguez, the case involved school financing in the state of Texas. Texas, like most states, funded its local schools by local property taxes in the district. The consequence of that, since there are wealthy districts and poorer districts, is that the amount of dollars spent per student varied dramatically, as much as 5 times, from one district to another in the state, on the basis of the local real estate tax base. And that was challenged as a violation of the Equal Protection Clause, that the state has a responsibility to provide education equally. To the extent it provides education, it has an obligation to provide it equally to its citizens. And the dissenters, including Brennan, Marshall, White, and Douglas, took the view that the right to education is a fundamental interest under the Equal Protection Clause, and disparities in education provided by the state need to be justified by something more than a rational basis. 5 members of the court, including all 4 of the Nixon nominees, again taking a restrained approach, said, no, we're not going to go there. We don't agree that education is a fundamental interest, and the only test that needs to be applied is rational basis, and this law is rational. So that's a demonstration of the judicial conservatism, restraint in that context, and an example of cutting the doctrine short. And so that doctrine, which was central to the Warren Court jurisprudence, essentially has been frozen in time as of Rodriguez. There have been no extensions of the doctrine since 1973. Okay, the final example is Roe versus Wade. Roe is obviously the most profound and dramatic decision handed down in that term. And interestingly, it did not divide the court in any sort of strong way. 3 of the Nixon nominees, Blackmun, Berger, and Powell, joined Roe v. Wade, and only Justices White and Rehnquist dissented. So even at that time, the idea of a conservative justice included 3/4 of them agreeing with the decision in Roe v. Wade, which was obviously judicial activism to a very high degree, and obviously controversial. So again, it tells you how far we've gone in the meaning of a conservative justice. There's absolutely no question that the 5 conservatives on the court today would not have decided Roe this way. So the real issue in Roe was not about the outcome, which was actually pretty clear. It was about writing the opinion and coming up with an argument that would be credible. And Blackmun, who was the author of the opinion, had some difficulty satisfying the different other justices on the case. And Brennan actually took a very large role in helping to craft what became the majority opinion in Roe, and working with Blackmun on that. The interesting thing about Brennan and Roe was that Brennan was a Catholic. He was the only Catholic on the court at the time. And this for him was a real issue of how to think about his personal values and his religious values and his responsibilities as a justice. And he clearly had to think hard about this in 2 ways. First, he needed to be sure he didn't allow his religious views to dictate his position of the case. And he also needed to be sure that he wasn't allowing his desire not to let his religious views dictate his position in the case. that is the perverse effect, which is, I so much want to demonstrate that a Catholic can reach the right result even though he's a Catholic in a case like this, that you'd actually perversely then reach a result that legally you might not agree with. So Brennan really struggled with that. It was interesting to work with him as he did so. When Roe was decided, nobody in the court could have imagined that it would have the political significance that it has come to have. It was thought at the time to be a controversial case legally. It was a difficult legal issue. The justices were certainly aware that it was a stretch of prior precedent, an extension of prior precedent. But none of them believed that it would be a big deal a year later. And in fact, it's interesting that when Stevens was confirmed, no one asked him a single question about Roe versus Wade. Even in 1976, it just wasn't thought of as that hot button an issue. That came later, closer to 1980 and beyond. But the first indication the justices had about how much this issue would be inflammatory was in the weeks immediately after Roe, when the court was inundated with hate mail, much of which was orchestrated. It was kids in parochial schools writing form letters, but there were hundreds upon hundreds of boxes of mail piled up in the corridors of the Supreme Court. And this was probably unprecedented. I'm sure unprecedented in the lifetimes of the justices then on the court. And the problem was there was no mechanism for opening it because there was no one in the court who had this job. And the people who were most intent on getting the mail, it turns out, were the law clerks, because many of them at this point in the year had interviewed with law firms in the fall and were waiting for the reimbursement checks. So at 2 in the morning, they were the ones in there looking for the letters. Brennan and Blackmun took a very different approach to how they would deal with these letters. Brennan and Blackmun got by far the most letters. Brennan because he was a Catholic, and Blackmun because he authored the opinion. And we're talking about several thousand opinions, letters each, maybe 10,000 each. Brennan's view is, I don't want to look at any of that. It's all outside the appropriate realm of what I'd actually be considering as a judge, and as far as I know, he never read a single one of the letters. Blackmun, on the other hand, insisted on reading them all. And this tells you something about Harry Blackmun, by the way. But there was a moment that I observed that I like to think was absolutely fundamental in the education of Harry Blackmun. One night, very late, around 2 o'clock, I was still working in Brennan's chambers, and I was working on a case with one of Blackmun's clerks. And I went over to Blackmun's chambers to see if the clerk was still there, and he was not, and all the lights in the office were out, with the exception of a green reading light on Blackmun's desk. And I could see him through the secretary's office, and I could see Blackmun through that entranceway. And he was sitting there with his glasses down on his nose, and a huge pile of letters, all opened up, taken out of the envelopes, and another huge pile that presumably were face down, the ones he'd already read. And his legs were crossed up on the desk, and he was just reading these letters. And I remember at the time thinking, this has got to have a real impact on this man. And because these letters basically said, you're a murderer, you're a killer, how can you kill my brother, who isn't born yet? And I became convinced, maybe this is just I liked the poetry of it, that it was that experience is what began the transformation of Harry Blackmun from being a conservative justice to being a liberal justice. That in that moment, I think he understood what it meant to feel like an outcast. And that he began to see the society differently, the claims being made differently, and the role of the court differently, as a consequence of the pain that he dealt with in that experience of being so excoriated. Anyway, I will stop now and open the floor for questions or comments.
Bob Woodward and other writers have sort of attributed a lot of Brennan's success, particularly after the Warren Court, to sort of his own personal charisma and his ability to persuade other justices. And I was just wondering if there are any cases or any stories that you had where that sort of came to light.
So, I mean, I gave you several examples where it didn't work, right? The obscenity cases, Frontiero, are good examples of where he was deeply frustrated. And he would come back from conference on some of those days when he was losing 5-4, and he would literally weep at times at how frustrating it was that he saw them dismantling the framework of constitutional law that he and others on the court had worked to create. Were there any cases? Yes. There were a couple of cases where he succeeded in doing this. The Keys case involved a desegregation issue out of Colorado, where, if I recall, Brennan wrote the plurality opinion, but it was a majority that he managed to put together. And so that would be one example. For the most part, we lost in this year. And this was also a really difficult experience for Brennan, because he had defined himself as, in many ways, the chief architect of the Warren Court. And he was the one who frequently worked to get that necessary fifth vote. Because even in the Warren Court, although there were some years where they had 5 solidly liberal justices, most of it they didn't. And most of it you still needed to get the vote of a John Harlan or a Hugo Black on an issue not involving free speech, or Stewart or White. And he was usually the one who was very effective at doing that. In this term, it was frustrating to Brennan because he couldn't succeed on issues he cared deeply about. But the way he did it was not so much by persuading. In my sense is that it was not so much by persuading that I'm right and you're wrong. It was more his ability to find common ground. That is, he was very effective at figuring out what it was that was leading his colleague to think differently about the case, and then to see if there was some way to craft an opinion that would be both acceptable to him and acceptable to the colleague. And so it was less a matter of persuasion than it was being really ingenious about finding ways to somehow restructure the argument so that it satisfied the concerns of the person who otherwise might be inclined to dissent. And that he was very gifted at.
Yeah, in the current vein, how do you see President Obama's problem in presenting a new nominee to the Supreme Court?
Well, his problem is entirely political. A big problem, in my view, is that, and the reason I focus on this business about the rhetoric of conservative and liberal and so on, is that over the past 40 years, the idea of a conservative justice who calls balls and strikes, who's restrained, who follows the meaning of the Constitution and doesn't make it up as he goes along, has become so embedded in the public consciousness that not only the public, but law students and lawyers think of kind of the mainstream is somewhere between Souter and Roberts. But that's not the mainstream. That's well into the conservative side of any reasonable spectrum of legal thought. But people have come to think of that as the mainstream. And so the first difficulty Obama faces is in persuading the public that a nominee who is, let's say, as liberal as John Paul Stevens, who's a conservative, or a moderate as he eventually became, is okay. And the difficulty is that the public debate about this issue will immediately lead to some nominee like that being accused of being some radical liberal. So Diane Wood's a good example. I mean, Diane Wood is somebody I've known for 25 years. She's a very moderate to moderate liberal person. People like Dick Posner and Frank Easterbrook, who work with her all the time, both on the faculty before they became judges and also on the court, would say that she's a craftsman. That's her primary thing about Diane, is that she's a very good lawyer, very careful analytically, very good at finding common ground the way Brennan was, and not an ideologue. She leans to the liberal side of things, but the idea that they who know her well as colleagues and are very conservative would see Diane as someone who's out of the mainstream, they would regard as ludicrous. But that's the way she'll be characterized, is already being characterized as out of the mainstream. So much of this now is about public impression. And one of the things I fault Obama on for example, is not being willing to take this on in a more direct way. And I understand why he doesn't want to pick every fight he could possibly pick at the same time. But I happen to think this one's an important one, and it's a difficult one. And the longer one allows this to continue, the more difficult it's going to be ever to change it. So I think the problem he has is that he's got to either appoint someone who's a stealth nominee, whatever that means, or someone who's a good deal more centrist than he himself would like to appoint to the court, unless he's willing to take on a political fight at a time when I think he's not eager to do that. So I think that's the real constraint that he has.
What was Brennan's relationship with Chief Justice Burrage, and what did he actually think of him?
Well, I mentioned earlier that Brennan loathed Richard Nixon. There were three people, I think it's fair to say, that Brennan really disliked. Joseph McCarthy, Richard Nixon, and Warren Burger. And Brennan wasn't alone in that. I think all of the other justices disliked Burger. He was pompous and officious and had no subtlety. And so he was a bit of a bull in a china shop. And he did a number of things in his official capacity that were seen as manipulative or inappropriate by his colleagues. So Brennan had, I mean, they got along fine personally, but Brennan had no use for Burger. I mean, he was the only justice who Brennan would talk about in chambers with the clerks in a way that was kind of scornful. And it wasn't about intelligence or ability. It was just about being kind of a crude, inept person at dealing with other people.
What do you think the most important characteristics are to a justice getting his or her way or being successful in shaping government?
So, okay, one of the characteristics that are most important to a justice in achieving his or her goals within the court, in shaping doctrine. One of them is having a vision of what it is you're trying to do and why you're trying to do it, and having a compelling legal argument that others find persuasive. The bottom line, let me make this as an important footnote. The bottom line of my experience on the court was that I came away from it with a very high degree of respect for the institution. Fundamentally, the justices were trying to do their job in exactly the right way. They were applying the Constitution, whether they were liberals or conservatives. They were not making up the law to suit their own preferences. Who they were and what their backgrounds were and what their perspectives were affected their understanding of the court and the Constitution. But I never saw a single instance in which justices on any point on the spectrum behaved in any way that was other than appropriate to the core task of the court. And that was actually very impressive. I mean, nobody log rolls, nobody trades votes, nobody cuts deals. It is, from that standpoint, a remarkably admirable institution. So one thing I think a judge needs to succeed in that environment is, because of the point that it's made, is what they really do care about is getting it right, is being able to convey a compelling legal argument as to why your position is right, and to force a judge who's inclined not to go your way to recognize that maybe your way is right, even though he'd prefer to reach a different result. That's, I think, one absolutely critical characteristic. And the other, I think, as I said, is the ability to find common ground and to be conciliatory. I mean, if you want to get people to join an opinion that they're otherwise inclined not to join, it's often the case that you have to shape the opinion to make it acceptable to the other justice. And one of the reasons why opinions sometimes appear to be unpersuasive or less persuasive than they should be is not because the justices, or God forbid the law clerks, are not brilliant. The justices aren't. But because compromises have been made. And therefore, the justices will know that the opinion they filed doesn't dot every I and cross every T. But in order to get enough people to sign it, they'll make compromises which are not visible on the face of the opinion, but would certainly be visible if you saw track changes. And so the ability to do that is I think, really important to be effective in that way.
On that note, in the past 40 years, if you will, it seems as though presidents have nominated justices whose decisions they hope they can predict. And which makes the whole process you're talking about trying to convince people in court to switch their votes more difficult. Do you ever foresee the president trying to nominate a person like Congress or Kennedy more recently, and I guess someone like perhaps Black back in New York that would be able to be persuaded, and that was the goal of nominating?
No. I don't foresee the possibility of a justice appointing a president appointing a reasonable justice who's open-minded and doesn't have views that they believe they can predict on some issues. It would be ideally nice to do that. You'd want some justices on the court who are like that. But I think that the change in American politics has become so dramatic over the past half century that it would be very difficult for a president to do that. The stakes are too high from their perspectives. And so they're going to want to appoint justices who they believe will see the law in a certain vein. Doesn't mean they can predict how they'll vote on particular cases. Oftentimes you really can't, and presidents are frequently surprised about that. But it remains the case that they are going to try to appoint judges who will see the law from this perspective that they think is preferable rather than the neutral one. I mean, that would be a very magnanimous approach. I don't see any president following it.
So at the same time that originalism
You got it.
Originalism was developing as a judicial philosophy, more liberal theories were also developing. So Dworkin's theory and Sunstein's theory. Do you see those more liberal theories as having an influence on Supreme Court justices, or if they don't yet, do you think they'll have an influence sometime in the near future, since the people who are going to be nominated as Supreme Court justices now sort of grew up learning those liberal theories?
I don't think those theories will have much impact. Dworkin's view is very philosophically oriented. And it's interesting, Dworkin's almost never cited by the Supreme Court. He's writing for a different audience. He's basically writing for academics. And I don't think the justices would be particularly inclined to follow Dworkin's way of reasoning because they don't think that's law. And with respect to Sunstein's views are largely reactive to the conservatism and the conservative activism of recent justices. And I don't think he offers an approach that represents a liberal philosophy or methodology. It's simply an argument for why conservatives should be moderate. And from that standpoint, it certainly doesn't pose a very compelling argument for a liberal philosophy of judging, other than what Sunstein's approach really does is go back to the idea of judicial restraint. And that's really not Sunstein. That's really Sunstein trying to persuade conservatives to be moderates. And so I don't think that actually will. That might have some weight with some justices on both sides, but in the end, it won't. It certainly won't be the liberal argument for how judges should approach the law. Time for one last question.
Obviously, they voted together quite often, and I was curious about the development of the relationship between Brennan and Marshall.
I don't know that Brennan and Marshall knew each other before Marshall joined the court. Undoubtedly, they met, but I don't think they had a personal relationship before Marshall joined the court. They were very close. The chambers were next to each other, which was coincidental, but which promoted kind of closeness between them. Brennan would often go over to Marshall's chambers, or Marshall's come over to Brennan's for the two of them to chat, sometimes about cases, sometimes it's about stuff. I think Marshall was the only justice I can recall coming into Brennan's chambers just socially in that way. It wasn't a business reason. It was just coming by to sort of talk. They admired each other enormously. They voted together to the extent they did because they had the same basic judicial philosophy, the same way that Roberts and Alito are likely to wind up voting together very high percentage of the time, although not today. So it's not that they're sort of working together in conspiracy, and found himself often writing concurring opinions rather than joining Berger's opinions just to annoy him. And one last thing, the other thing that's happened fundamentally since then is the relative dearth of majority opinions today. I mean, now there's much greater temptation for justices to go off on their own and write concurring opinions here, concurring opinions there, join this part but not that part. I don't know exactly what the explanation for that is, but it makes for more chaos in the law, which is unfortunate. And it also, I think, is reflective of the fact that you don't have people who are as good as Brennan going around and trying to figure out how to find a majority. They pretty much do their own business on their own, circulate their opinions, and very little effort seems to be made, although I don't know this firsthand, to bring people together. So you've got these scattered opinions with 8 different justices writing. Okay, thank you very much.